their right to innocence is being taken away. It is a human right which should be the accused persons. Some of them are schoolboys, where their schools are known. And now that they are done in school, they will go to their parents' home. These are young men. The safety of the accused persons. That they should be remanded in custody so that they will be prepared against the accused persons. The investigation officer confirmed that the even doesn't know the user of Photoshop. This could be issued if you are being dropped somewhere and dropped with knuckles. And
Court to record your submissions.
very well done. Who is Piedmont?
If Piedmont was seen, the others were shouting at him in the video that he should.
Yes. So you know?
The PC may be seated.
Yes, it might be seated because we need to have our submissions. Okay.
Who knew the faces in the video, arrested the accused person and sentenced them to release.
So do you know the names of that? Are they witnesses?
So do a forensic analysis so that I can identify the faces.
So at the moment you don't have sufficient evidence to charge this person. Is that a solution?
It is not sufficient.
So which evidence do you have then at the moment as we speak? Someone called Piedmont who is not
It's not before court.
who's not before this court and he was actually captured in that case.
Yeah, it was actually captured in that case.
Would ease
You know, I seek to
and whether the complainant had an issue with the accused persons or not, you will not discuss. How many people were you able to see that video?
I was able to see around 8.
Around 8. So these are 8 accused persons?
No,
Yes.
there are people, there was.
April 2024, and the supporting affidavit of PC Jefferson Mwiti, deponed on similar date. The court has also noted the submissions made by both prosecution and the respondent's counsel. The application seeks to have the plea deferred and the respondents detained for 21 days on grounds of ensuring completion of investigations, these being forensic investigations, age assessment, mental assessment, and tracing of the victim and others seen on the indicated video clip. The detention of the respondents is also sought as the applicants pray that bail and bond pending plea be deferred on grounds that the respondents are flight risks owing to no known place of abode, as well as for their own well-being and security, as they stand to be harmed by rowdy members of public owing to the widely shared and circulated video clip of the incident, which elicited their arrest and production in court. The court shall address these two issues and make a determination. The respondent's counsel informed the court that there was no complainant in the matter. There was no charge against the respondents, and the video clip so mentioned was not tendered in evidence. Counsel sought the court to deem the production of the respondents premature owing to this and sought for their release. The court finds that these reasons are the grounds upon which the application is made. The court agrees with the submissions by the prosecution that the Republic is the complainant. In all criminal matters, the Republic is the complainant, as it would be untenable for victims of an offense to prosecute their own cases. In this case, the position by counsel that there is no complainant is misplaced. It is well submitted by prosecution that they required time to undertake investigations upon which they would proceed. Again, as rightly put, the persons before the court are suspects and are yet to be charged, hence the application by the prosecution to have the plea deferred. The court thus finds that there are sufficient grounds to have the respondents detained so as to avert interference with investigations. On the issue of deferment of bail and bond pending plea, it is well established, as was stated by both the prosecution and the respondents' counsel, that bail and bond is a constitutional right. However, this right may be limited if adequate grounds are provided for the same to be limited. Opposing counsel informed the court that there were no documents or evidence to establish that the respondents were a flight risk or their lives were at risk. Indeed, the prosecution did not avail any evidence of the presupposed harm upon the respondents. It also did not prove that they were a flight risk, as the respondents were traced and taken into custody by the area chief and Nyumba Kumi elders and presented to Obutio police station, where they were booked. However, it would be a disservice for this court to overlook the contents indicating the alleged crime the respondents are arrested over, and the public interest and outcry that the same has elicited as submitted by the prosecution. It is for this reason that the court deems it is in the interest of justice and public good that the respondents be denied bail and bond pending plea and that they be detained. The court, however, finds the period prayed by the prosecution of 21 days unjustified and shall adjust this period accordingly. The upshot of this is that the application dated 12th April 2024 is allowed in the following terms. The plea is deferred. The respondents are to be detained for 14 days at Chebunyo police station. Bail and bond for the respondents pending plea is deferred.